The Constitution is relatively short as important legal documents go. If you don't believe me, take a look at the state constitution. State constitutions are always much, much bigger than the U.S. Constitution. They go into more detail. The U.S. Constitution was intentionally left somewhat inexact. The result has been that it has needed interpretation, and we're going to talk a little bit about that as we go along. But for a short document, there's an awful lot of information in it, and in the hour and a half that we have this evening, we can't study everything. So I've made some editorial choices of what we'll focus on, and primarily what I'm focusing on are constitutional issues and topics that seem to be coming up in the news and in what's going on in the country. And I want to focus somewhat on those so that as these things are happening, hopefully we have a good understanding of what's happening. I've spoken to a number of people who, if they ever really took time to look at the Constitution, it was probably back in high school. So it's been a while, and I think to be good informed citizens, we need to review it every once in a while. One thing I do not want to do this evening, and that's get into pros and cons on issues. There are forums for that. This is not that. This is for information, for review, for getting us all kind of back up to speed on the basics. And then we can go to other forums and talk about pros and cons, whether this particular portion of the Constitution is being adhered to and that one maybe isn't. We're not going to get into that tonight. That's for other forums. I welcome questions, as long as let's try to keep them reasonably short, because as we do have a lot of ground to cover in a relatively short amount of time. One question I'll answer right off the top, some of the spelling is funny. Keep in mind that in the 1780s they were still using British spelling. And also some words get capitalized that we wouldn't bother capitalizing them today. So just go with it. It's what it is. During the Revolutionary War, during the War of Independence from Britain, there really was no document that governed how the United States, what had been the colonies, what were becoming the United States, would be governed. There was no constitution, nothing along those lines. Once the war was over, once independence was won, the states in the Continental Congress, the ruling body that had started the war on behalf of the colonies, decided we need some kind of framework on how we're going to govern this new independent nation. And the states came together and they wrote something called the Articles of Confederation. You wouldn't recognize it when you compare it to the Constitution. It left the central government extremely weak. It had no power of taxation. It had to beg money from the different states. Many of the states continued to each one print their own money, charge import and export duties at the state line, something that it's hard to imagine today, right? We cross state lines without even thinking about it anymore. But that was a very different thing. But very quickly, the leaders of the new nation realized this wasn't working. It was too loose. It gave the central government no authority, no power. It was completely at the mercy of the individual states. So it really wasn't like one nation. It was kind of like 13 different nations in a kind of a loose alliance. And they didn't want that. They wanted something stronger. And so in 1787, the Congress of the Confederation called for a constitutional convention. Delegates from most of the states gathered in Philadelphia in the summer of 1787. And it's fascinating reading to read stories of that summer, of that convention. And on the back table, when we're done, you might want to take a look. There are quite a few books about the Constitution and the Constitutional Convention. It's fascinating reading. And in the end, what they did, what they actually had been called on to do, was to decide how to improve the Articles of Confederation. And in their discussions, they very quickly realized this isn't going to work. We really need to throw it out and start with something completely different, completely new. And so in the end, they went beyond their mandate from the Congress. They completely ignored the Articles of Confederation and came up with this new document called the Constitution. The Congress accepted it and sent it out to the states for ratification. It was ratified by 1789 and went into effect at that point. So it's interesting to look at the preamble. Like me, many of you may have had to memorize it back in junior high. Well, eventually all of them did, but not right away. When a new state joins the Union, as it always had to ratify the Constitution as part of that. Initially, they called it that. Very quickly after the nation got going under the Constitution, they would call it that Congress accepted the application for statehood of the new state. But in effect, it's kind of the same thing. So the preamble starts with the words, "we the people," which has made for one interesting discussion down the centuries. Is the Constitution something that was created by the people of the United States or through their representatives by the people? Or was it something that was created by the states that had sent the delegates to the convention? And it really depends kind of on your political philosophy about which is right. But it starts with "we, the people of the United States." In order to form a more perfect union, I've highlighted some of the things I want to particularly talk about. In the context of the Articles of Confederation not having worked, that phrase really stands out to me. In order to form a more perfect union than what we've had for the last few years under the Articles of Confederation. And to do all of these things that we have read so many times, establish justice, ensure domestic tranquility, and so on. Do ordain and establish this Constitution for the United States of America. So keep in mind, what that says is we the people do ordain and establish. There is a concept in political science of sovereignty. In a monarchy, they refer to the king or queen as the sovereign, in whose name everything is done. Under the United States Constitution, it is we the people who are sovereign. And that, at least in part, is based on this language of the preamble, that it was we the people who ordained and established this Constitution. So right from the beginning, it's an attempt to include everyone, all of the citizens, in this experiment. It was certainly an experiment in 1787. I very strongly believe that it is still an experiment in 2017. Historically speaking, we haven't been doing it very long. And we're still some noise in the wheels as they grind. And we keep working at it and keep trying to make it better. The first three articles, the Constitution is divided up into articles. The first three articles establish the three branches of the federal government. So we're going to go through that. And if you remember, we're always talking in terms of those three branches of checks and balances. The idea of the people who were at the convention was that they didn't want any one branch of the three to become all-powerful, because that would create an imbalance and a likelihood of some form of dictatorship or tyranny. And that's what they had just thrown off. And so they were trying to avoid it. So as we look at the checks and balances, and also we're going to look at some of the compromises that were made. Politics is the art of compromise, if anything is going to get done. And the Constitutional Convention was a perfect example of compromises. Some of them, 240 years later, don't look maybe so savory. And we'll take a look at some of those. And some of them are, we've just gotten used to them and they work. So Article 1 is the legislative branch. All legislative powers are vested in a Congress, which shall consist of a Senate and a House of Representatives. Right away, that was a compromise in the convention. You had big states among the 13, Virginia, Pennsylvania, Massachusetts, in terms of population. You had small states. You had Rhode Island, Connecticut, Maryland, Georgia. Not so big. The big states wanted a one-house legislature based on population. Well, sure they did. The small states wanted a one-house legislature with equal representation from each state. They compromised. That's why we have a two-house Congress. One house in each way, right? That's not necessarily ordained by nature. There's actually one of the 50 states that has a unicameral legislature. Anybody happen to know which one it is? Nebraska, yeah. All the other 49 all have two-house legislatures modeled on the Congress. Nebraska said, what are we going to waste that time for? They went with one. So the members of the House of Representatives are elected every 2 years. That was very conscious on their part. Especially keep in mind transportation and communication at the end of the 18th century, right? The only real way they could communicate with their constituents was to go home. And for the ones who lived, way north or way south from Philadelphia or later New York, which became the capital, it was pretty difficult. But they wanted the members of the House to be closer to the people. They had to stand for re-election every 2 years, which gave the people an opportunity to change if they didn't like what their representative was doing. Section 3, or paragraph 3 here, talks about how the number of representatives will be apportioned between the states. Remember, this is the House that is based on representation by population. Here is another compromise, and it's a compromise that, as I mentioned, is not so savory, especially from this distance. The southern states, the slaveholding states, wanted the slaves to be counted in full to increase their representation in the House of Representatives. The northern states, the non-slaveholding states, said absolutely not. That's, these are not citizens, they don't function as citizens. We're not going to go with that, which certainly was also in their best interest as smaller states to better balance in their favor the representation. The compromise was that the whole number of free persons, including those bound to service for a term of years, indentured servitude, that's not slavery, right? And excluding Indians not taxed, 3/5 of all other persons, in other words, slaves. So the founders of the Republic counted slaves as 3/5 of a person. There were members from the North, from the non-slaveholding states, who wanted to write into the Constitution, some of them, an abolition of slavery completely. Southern states certainly weren't going to go along with that. Their fallback position was to ban the importation of any more slaves into the country. The compromise there was the South agreed, okay, we'll let you ban importation of more slaves, but only in 20 years. So there's a provision later on in the Constitution that no law can be passed banning importation of slaves before 1808. So you see the compromises that had to happen. And already at the Constitutional Convention, we're seeing some of the splits, some of the differences that a number of decades later are going to result in the Civil War, because these compromises could hold for only so long. Paragraph 5, the House of Representatives shall choose their speaker. That's not all important. And the House of Representatives shall have the sole power of impeachment. Now, that's a word that's starting to be thrown around. However you feel about that, it's out there. And we have to understand how it works. Some of us remember that impeachment of a president has happened in our lifetime, back in the 1990s. Now, impeachment is not removal from office. Impeachment is like an indictment. And it's the House of Representatives that the Constitution specifically gives the authority to come down with that indictment or to impeach any federal officer, including the president. And as we'll see, it's the Senate that then sits as a trial court for the impeachment. And again, those of us who remember, old enough to remember the 90s, remember that that's what happened with President Clinton. Yeah. That is correct. There is no recall process for federal offices. I've heard a little bit of discussion recently about some people wanting to add that. Wouldn't hold my breath. Yeah, no, that's a state-by-state thing, and it specifically has to do with state offices in the states that have it. No recall under the federal Constitution, no. However, one of the things that is in the Constitution is that each house has sole authority to recognize the membership of somebody who has been elected, or to say that this person has not been elected properly, or a member of the House, or that the House can deny membership to a member of the House by certifying that the election was not proper, or something along those lines. The Senate can do the same with one of theirs. Doesn't happen very much, but they do have the authority to do that. So the Senate, composed of 2 senators from each state, notice this, chosen by the legislature of each state. That was the original arrangement, so that the senators originally weren't really representing directly the people of their state. They were representing the state government. They were representing the state legislature. As we're going to see, that was changed by an amendment in the early 20th century, so that for a little over 100 years now, senators are elected by direct vote of the people. And that fits in with an interesting pattern that we will see when we get to the amendments. As amendments were added over the last couple of centuries, many of them have to do with expanding who gets to vote in federal elections. There's never been one that contracts who gets to vote, that makes the numbers smaller. There are several, and we will see that expand it. At the time of the Constitutional Convention and the first few decades of the United States government, the states were left to decide who gets to vote in all elections, including federal elections. In fact, in a couple of places, the Constitution, see if I can find it, says that I'm not going to go looking for it, that those who may vote for these federal offices is defined by who gets to vote for the most numerous branch of the state legislature in each state. So the state got to choose who got to vote, and in that day and age, it was white, male property owners. Adult, of course, over 21. And as we're going to see, over the term of our history, that has been steadily expanded. So, Senate begins 2 from each state. It's kind of funny, there are some states that have 2 senators but only 1 member of the House of Representatives. There's a special election in Montana, I think actually tomorrow, to fill that vacant seat. And Montana is a very small state in population. So they get 2 senators, they get 1 member of the House of Representatives. It was kind of funny. I'm originally from California. We have 2 senators, and at last count, I think 56 members of the House, something like that. It's the largest state in population. The vice president shall be president of the Senate, but shall have no vote unless they be equally divided. There's been talk about that in the news since the last election. The Republicans have a 4-seat majority in the Senate, 52 to 48. So if 2 Republicans don't vote or vote with the Democrats, it's a tie vote, but the vice president then gets to vote, and since he is a Republican, chances are that whatever the Republican majority wants passed, he will go with them. But that's the only time the vice president gets to vote. Yes? Question is, what's the rationale for a senator serving 6 years instead of 2? Or 4. Again, they wanted the House to be close to the people, but they saw the Senate as a kind of a moderating influence on what they expected to be a more populist House of Representatives, where they thought that debates in the House might be more emotional, more ideological, and they saw the Senate as a body of statesmen who would kind of be more even-keeled and more statesman-like. And so a 6-year term would allow them to be kind of above the fray for a good part of time until they had to face. And keep in mind, again, for the first 100 and some years, they were elected by the legislatures. So, you know, their electors, the people they had to lobby to get elected, was a very small group. And so it was this idea of being above the fray, of being more statesmanlike. A third of the Senate is up for re-election every 2 years. And in fact, there's a whole paragraph here that we're not going to spend time on, where they say that, you know, once the first Senate gets elected, and you have to fill all the seats right away, the first thing the Senate has to do is divide itself up into 3 classes. One group that'll be up for re-election in 2 years, another group that'll be up for re-election in 4 years, another group that'll serve the full 6 years. And that got that staggered election thing going that we've had ever since. The Senate shall have the sole power to try all impeachments. And when the President of the United States is tried, the Chief Justice becomes the head of the court, in effect, and presides over the Senate, which again is what happened in the 90s with President Clinton. And no person shall be convicted without 2/3 of the members present. So that's a high bar, as it should be. And paragraph 7 is kind of interesting too. All the Senate can do, or the House in impeaching and the Senate in trying, is they can throw him out of office, which, by the way, hasn't happened yet. We've had 2 impeachments of presidents. In both cases, they were not convicted. First one, or the second one, as we've been saying, was President Clinton in the 90s. Anybody remember who the first one was? Andrew Johnson, right after the Civil War, right after Lincoln's assassination. He was not real popular with the Congress, but he was saved by 1 vote from being thrown out of office. But a conviction by the Senate is not a basis for a criminal conviction. It doesn't mean that the president couldn't be, who's been removed from office by impeachment, couldn't be tried for a crime once he's out of office. Although that hasn't happened either. The one case where some people thought it might happen, we've had 1 resignation of a president. Anybody? Nixon, right, in the 1970s. There were some people who wanted to see him criminally tried. After he resigned the office, President Ford, his successor, immediately gave him a pardon, and that was off the books. But it could have happened. Here, as I mentioned this before, each house shall be the judge of the elections, returns, and qualifications of its own members. I mentioned that a few minutes ago. Section 7, paragraph 2, every bill which shall have passed the House of Representatives and the Senate shall, before it becomes law, be presented to the President. If he approves, he signs it, it becomes law. If he doesn't, he returns it. And we use the term today, veto. The word isn't in the Constitution. It's just something that got into usage. If I remember my high school Latin correctly, I believe the word veto means I forbid. In vetoing a bill, the president has to send it back to Congress with a message of why, and perhaps with suggestions of, if you clean up this provision a little bit and change that one over there, then I'd sign it. So it's not just a flat no, it's a working together, the 2 branches. So we've got, you know, everything that's going to become law has to be passed by both houses of Congress in identical language. So there's a check and a balance between the 2 houses of the Congress, right? If they don't both pass it in the same language, it isn't law. In fact, you can see that going on right now. The health bill that the House of Representatives passed a couple of weeks ago, the Senate, the Republican majority in the Senate has basically said, we don't like your bill, we're going to write our own health bill. Which means, and if that passes the Senate, then the 2 houses have to come together in a conference committee and work it out. find ways of coming up with an identical bill that both houses will pass. That doesn't happen, it doesn't become law. It then, if they do pass it, it goes to the president. Here's a check and a balance on the Congress. If the Congress oversteps or does something that the president thinks is wrong, for whatever reason, the president can veto it. Gives a fair amount of power to the president, but there's now a check and a balance on the veto that the Congress can reconsider. And if both houses of the Congress vote to by 2/3 of each house, not any longer a simple majority, which is normally what you need the first time around. If each house repasses the same bill with a 2/3 majority, it's law in spite of the president's veto. They could, but the president would have to sign the bill that the Congress passes, and may not want to. So all of this is, the checks and balances on each other to make sure that nobody runs away with the power. Yes? You're right. An executive order is not law. What it really is an instruction to the departments of the executive branch. Here's the boss saying, this is what I want you departments that work for me, this is what I want you to do, or not to do. And in fact, if you look at the executive orders that have been signed since January 20th, there have been quite a few of them, and some of them have been quite controversial, and some of them have been suspended by the courts. What they really are is they affect the functioning of the executive departments. The executive orders about immigration and refugees is in effect instructions to the immigration service as to who to let in. This doesn't need law. There is an immigration and naturalization law that governs that, but every law that's passed by Congress is vague enough that you then need a whole set of rules as to actually how is it going to be applied. And there is a big body of literature called the Federal Register. If you ever really have trouble sleeping, I highly recommend it. But it's what's called administrative law. And in every department, anybody that works with any executive department of the federal government has to know the rules that apply to that agency really, really well. You can see an example of how those work. Right now, there's an issue about net neutrality that's before the Federal Communications Commission. The FCC has issued a proposed new set of rules, but statute requires the executive department that's proposing new rules to make it public for a comment period. And members of the public have the right to send in their comments. This is something as citizens we should all be paying attention to. Keep an eye on things that are of interest to us. You are just as qualified as anybody, as a voter, to send in your opinion. And then the agency, in this case the FCC, once that comment period is over, I think it's 90 days, but don't hold me to that, they, or their staff at least, will take all of the comments that have been submitted and present them to the commission in some kind of a shortened version so that they can take into account public opinion about these rules. Case law is what the courts decide. I mentioned earlier that a lot of what's in here is vague enough to need interpretation as to how it gets applied. And I was actually going to make it a little bit of a quiz when we get to Article 3. But we're very used to the idea that the Supreme Court is the final arbiter of what a federal statute means. Actually, in most cases, it's the federal courts of appeals. Because in most cases that are in federal courts, you don't have the right of appeal to the Supreme Court. You have to apply and ask them to accept your case, and in most cases they don't. They're only doing maybe 200 cases a year. That's all. So most federal cases go as high as the circuit courts of appeals, and they establish the law. But whatever rule the final court in a case comes up with, that is the law on that particular point. And any lawyer, whether in a criminal, a civil, or an administrative type of proceeding, we'll have to go and look at all of the cases that interpreted that particular provision. In fact, I will show you in a little while, there's something called an annotated constitution. The little pamphlets that we have here have a few cases in them, but certainly not a full slate of them. I will show you where on the internet you can find an annotated constitution. And again, if you really have trouble sleeping, you can look. This is what I spent 3 years in law school doing a long time ago, of studying the case law about a particular thing. Now, as far as they relate to the executive orders still have to pass muster in terms of protections of rights that are within the Constitution. And we're going to see that more. We'll see it a little bit in the main body of the Constitution, but we're going to see it more when we get to the amendments. So hold the thought. Question was asked, how do I know as a citizen when there are rules being proposed by a federal agency that affect something that I'm interested in? Absolutely outstanding question. I think the best answer is get very familiar with the website of the agency that you're particularly interested in. Whether it's FCC, EPA, whatever it is, immigration, they have to advertise the fact that they are proposing changes to the rules, and putting it on their website's the cheapest advertising. So in this day and age, that makes it real easy. But it does require us as citizens to be a little more proactive. Question is the agency obligated to actually pay attention to our comments? Not really. I mean, yes, they are, but who's going to test it? And they can still decide, even if you get 99% on one side of the issue and the agency decides on the other side of the issue, they still have that power and authority. And in a system such as ours, the remedy that we have as citizens is to throw out the elected people who appointed them. And so the new elected people will appoint other people. So it isn't always, the response of the system is rarely quick. It is kind of slow. It is kind of glacial sometimes. But I've heard some people suggest that maybe that's just as well. Because an overnight revolution, anywhere in the world, always carries within it the seeds of its own destruction. I had forgotten that, thank you. Yes, Federal Register has a place where you can subscribe to notices of proposed rule changes. So there you go, even easier than looking at the websites. Thank you. So we've got checks and balances there. Section 8 is very important because it lists all the things that the Congress shall have the power to do. The people at the Constitutional Convention in 1787 in Philadelphia saw the government that they were creating as a government of delegated powers. If it says in the Constitution the government can do it, then the government can do it. If it doesn't explicitly say in the Constitution that the government can do it, then their attitude was the government can't do it. Now that's been interpreted drastically over the last 240 years, but this is where it begins. And many of these things are the things that the government under the Articles of Confederation didn't have the power to do. And so they're trying to remedy that, trying to form a more perfect union. Power to lay and collect taxes, duties, imposts, provide for the common defense, borrow money, regulate commerce. Now, paragraph 3, to regulate commerce among the several states. Up until about the 1930s, the federal courts, by and large, were very conservative about what they would accept that the executive branch could do. But during the Roosevelt administration in the 1930s and partly in the crisis of the Depression, the court kind of changed tack and ever since then has used paragraph 3 to regulate commerce among the several states as a way of saying, if anything that's involved in an issue in a case before the court crosses a state line, that is interstate commerce, and the federal government has the authority to regulate it. Not all justices on the Supreme Court have agreed with that, but that's been the pattern pretty much since the 1930s. Paragraph 11, Congress shall have the power to declare war. We've been in a few wars in the last few decades where there's been no declaration. That's been a subject of a lot of debate among constitutional scholars. That is a legacy of the 18th century. Most nations didn't have much navy to speak of, other than the British perhaps. And the governments would grant letters of marque, which was basically a license to declare oneself the navy of the home country, for a private ship to act as a naval vessel, in effect. The other side, of course, always said, no, you're just pirates. But it was an accepted thing in the 18th century in international law. Korea was a police action under the UN. I mean, the question was, since in Vietnam and also in Korea, there was no declaration of war by the Congress as there had been at the beginning of World War II, how could they institute the draft and all of that? Discussion for another day. There were people who argued they couldn't. So those of us who are old enough to remember the Gulf of Tonkin resolution, which the Johnson administration used as a legal claim to wage a war in Vietnam, which we later found out was a lie. It was a very big political issue, and there were very few members of the Congress who voted against the Gulf of Tonkin resolution, and many people considered them at the time to be traitors, unpatriotic. Some people think that they were vindicated later on when we found out that what the Johnson administration had presented to the Congress had never happened. So again, here we're seeing checks and balances. Many people see, beginning with President Johnson in the 1960s, Johnson certainly expanded the powers of the executive at the expense of the legislative branch. Many people saw a kind of an evening out of the power when Nixon was almost impeached and ended up having to resign in the 70s. It built up again. I think the executive branch, again took on more power in the balance under Reagan and under Clinton and under the second Bush after 9/11, which was justified by a national emergency. These have always been debated, always, as they should be. That's why the system is built the way it is. There should be debate. When the day comes that there is no debate, I'll start worrying. Section 9, the migration or importation, this is the provision that allows Congress to pass a law banning importation of new slaves, but only in 1808. No state can enter into a treaty or alliance with another country. We kind of laugh at that, But in the structure that existed before the Constitution, there were a lot of people who were worried about that. And if that had happened, the United States probably never would have happened as it did. So history is an interesting animal. Yes, sir, I'm sorry. Yes, I meant to bold that and I forgot, and thank you for catching it. Section 9, paragraph 8. No title of nobility shall be granted by the United States. Okay, we're good with that. No person holding any office of profit or trust under them shall, without the consent of Congress, accept of any present emolument, that's been in the news, office or title of any kind whatever, from any king, prince, or foreign state. Thank you for catching that. Yes, I did want to talk about that. What's an emolument? A gift of something of value.
Oh, right.
A gift of value. Yeah, no, clearly they can't accept a title of nobility, but without permission of Congress. I don't remember if Congress has ever.
There is a way. But
the Emolument Clause has very much been in the news, right? There are no federal court cases defining the Emoluments Clause. None. So we are in new territory. If you've been reading the news on this, there are people who are saying that because the president has not divested himself of business properties, business interests, that, for example, if a representative of a foreign state chooses to stay in a Trump hotel, that could be seen as currying favor with the administration, and he's gaining a profit from it. I don't know. There are no cases. Yes. The only way that a violation of the Constitution gets stopped is through litigation or impeachment. And we need to, and because both of these things are out there in the air, we need to differentiate. I mentioned that impeachment cannot be a basis for criminal conviction. That can be done separately, but it isn't the same thing. But also, we have to keep in mind, I think a lot of people who are beginning to talk about impeachment are kind of missing the mark a little bit when they talk about, has there been a violation of law? Well, but impeachment is not a criminal prosecution, it's a political act. And so, the grounds for impeachment, it does say high crimes and misdemeanors. What does that mean? I don't know. I don't think anybody knows for sure. And essentially, it is whatever the House and the Senate say it is, if they want to remove a president. That, there's clear litigation, there's clear case law on.
I'm sorry, what was the question?
Oh, thank you for reminding me. What's the definition of obstruction of justice? Which of course is being brought up by quite a few people as a potential grounds for impeachment. Not quite there yet, but that's certainly the basis for all of these investigations that we're hearing about in the news. Without stating an opinion, which I don't want to do, obstruction of justice means doing something to prevent an investigation or a prosecution from lawfully going forward. Impeachment is voted on by the House of Representatives, and then the Senate sits as a trial court, as kind of like a very big jury, and it's the Senate that decides whether or not the impeached president will be removed from office. And the two times in our history that a president has been impeached by the House of Representatives, Andrew Johnson in the 1860s, Bill Clinton in the 1990s, the House impeached, the Senate acquitted, which means that neither man was removed from office. Oh yes, there have been a number of cases of federal judges, not a lot, but a few down the years, where federal judges have been removed from office through the process of impeachment. Pretty much. Any elected or appointed office in the United States government, or in a state government. No, not an employee, but a secretary of a cabinet department, for example, or one of the deputy secretaries and so on. But your average employee in the field, no. That's not they could be fired if they do something wrong, but that's not an impeachment process. So Article 2 is the executive branch, vested in a president of the United States of America, hold office for a term of 4 years, together with the vice president chosen for the same term, and then explains basically the Electoral College. If you thought that we the people directly elect the president, you are sadly misinformed. As a matter of fact, in the last 16 years, twice, the Electoral College has chosen as president someone who did not win the popular vote. Twice. This last election in 2016 and in 2000, when Al Gore got more popular votes, but George Bush was elected by the Electoral College. There has long been debate in the country about doing away with the Electoral College. It kind of gives greater weight to the smaller states, in a sense. That would require a constitutional amendment, and we're going to see in a few minutes how that could happen. There is no proposed constitutional amendment per se before the public today. There's some discussion about it, and every time that happens, and it had happened a couple of times before, back in the 19th century, that you had one person winning the popular vote and somebody else getting elected by the Electoral College. From time to time there's been discussion, but there has never been, as far as I know, an actual amendment proposed to do away with the Electoral College. Yeah, exactly right. The Electoral College was written into the Constitution at the Constitutional Convention, in a sense because the people at the convention who were writing this document didn't entirely trust the people. And Thomas Jefferson wasn't there. If he had been there, it might have been a little bit different, because he did trust the people. He was the minister for the new nation to France at the time, so he wasn't at the Constitutional Convention. But this was, again, a compromise. There were some people at the convention who wanted a direct popular vote, and there were other people who said, whoa, that's, we don't entirely trust the people to know what's in their best interests, and so we want the states to appoint people who are maybe better educated, who are more familiar with political theory, with the issues of the day, and they will make a more statesman-like choice. Again, that goes back to a time when the franchise was extremely limited to white male property owners, at least age 21, or in some states 25. As we have expanded the vote to a much bigger percentage of the population, some people argue it's time to do away with the Electoral College. Again, we have the power to let our opinions be known to our senators and representatives that we would like to see such a thing happen if that's what we would like. How is it that the Electoral College was an advantage for the smaller states? At the time, there were only, of the 13 states, there were maybe 3 or 4 that really could be considered big in population. And the rest were a lot smaller. It gave in a straight popular vote, I don't know, making up numbers here, 50,000 people in Connecticut are not going to have as much of a voice as 500,000 people in Virginia. Now, the Electoral College originally did not require the electors of each state to vote in accordance with the popular vote in that state. Today, most states have passed laws at the state level requiring the electors to vote according to who won the popular vote in that state. But that's relatively recent. And in the early decades of the nation, the electors could vote for whoever they wanted to. Well, it kind of does. It's become really a mongrel. It isn't what it was, and it isn't what a lot of people want, and so among political scientists, there's more and more of a discussion, but it still hasn't reached critical mass among the politicians to propose an amendment. In the last election, the Democratic candidate won California by 3 million votes. Or no, nationwide by 3 million, but California by at least 1 million. She got the electoral votes of California, whether she got 1 million votes more than the other candidate or 1 vote more than the other candidate. So in a sense, all those extra votes are kind of wasted. They don't count, really, beyond the bare majority. It's a complicated thing, and very much subject to opinion. Yeah, here's the Emoluments Clause as it pertains to the president. The other one pertained to Congress, but it's the same thing, same idea. Did you know that the oath of office that the president takes is set out word for word in the Constitution? There it is, paragraph 8. What's missing from that? Yeah, I don't know how far it goes back, but the custom has been to finish that with "so help me God," but that's not part of the constitutionally mandated oath of office. Now, the president doesn't swear loyalty to to the United States. He or she doesn't swear loyalty to the government. It's to preserve, protect, and defend the Constitution. That's the president's job, and the oath taken by members of Congress is very similar. And they're all taking an oath, basically, to abide by the Constitution. Well, in theory, yes, and the same thing could be said about every member of Congress. When a member of Congress votes up or down on a piece of legislation, they should also be making a determination about whether this complies with the Constitution or not. So in theory, yes, each one of them can make up their own mind. But in practical terms, they generally go by the interpretation that the courts have given, to the extent that the courts have ruled on the issue of the moment. Sometimes there's an issue that the courts haven't yet ruled on. And so each one of them is supposed to make their own best judgment. And if there's a big difference of opinion on that, pretty much guaranteed it will eventually get to the courts. And the courts will figure it out. But once it's been decided by the courts, you go against that at your peril. You can. There's nothing that says you can't vote a different way, but you're kind of setting yourself up for the strong possibility that you're going to get overruled, and nobody likes that. President shall be the commander-in-chief of the armed forces, and the president may require the opinion in writing of the principal officer in each of the executive departments. That's what today we call the secretaries of the various cabinet offices. They hadn't started using that language yet, but that's what that means. The president has the power, with the advice and consent of the Senate, to make treaties, which require 2/3 vote of the senators present. And the president nominates, and again with advice and consent of the Senate, appoints ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. So whenever there's a change of administration, as we've just seen in the last few months, the heads of all the departments, going down about, depending on the department, 2, 3, sometimes 4 levels at the top of each department, those are appointments that the Senate must confirm. So again, we've got a check and a balance. That the president, in theory, can appoint anybody he wants, but then the Senate steps in and does investigations and asks questions, and we have seen that things come out in that process where sometimes the Senate refuses to approve, or there's a big difference of opinion. When the current Secretary of Education was confirmed by the Senate, as far as I remember, for the first time in history, the Vice President had to break the tie to confirm her appointment as Secretary of Education. There was that much difference of opinion. And the same thing with treaties. Anytime the President concludes a treaty with another country, the Senate has to approve it by a 2/3 majority. Checks and balances. And we also saw very recently an appointment to the Supreme Court, and to all the federal courts, really, have to be approved. We just had a vacancy filled on the Supreme Court through that process just a few weeks ago. Yes? If there are appropriations involved, it might just be, I haven't seen the language of it.
$7 billion.
Yeah. No, the question is about this treaty that the president just concluded with Saudi Arabia for several $billion in armaments. Yes, certainly if there's any federal money involved, it has to go past both houses of Congress for an appropriation.
2/3 still?
Not for an appropriation. No, that's a simple majority. If it's just a business deal that the president helped, although I believe, and I'm not an expert on this, that a contract for armaments with a foreign power is required by law to be approved by the Senate. I think so. Not clear, I'm not real sure on that one. Section 4, the President, Vice President, all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, those are fairly clear, right? Or other high crimes and misdemeanors. That's not so clear. So as I said before, if the House politically wants to impeach the President, they're going to do it. And they will find a way under that language to justify it. And same thing with the Senate in trying the case. Article 3, the judicial power of the United States, vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain. So all of the federal court system, every state has at least one district court, which is a trial level court. A number of states are included in a circuit court of appeals. Colorado is in, I believe, the 10th Circuit, which is based in Denver. Again, I'm originally from California and practiced law there. California's in the 9th Circuit, which geographically is the biggest. It includes certainly Nevada, maybe Utah, I don't remember, California, Oregon, Washington, Idaho, Hawaii, and Alaska. And that's based in San Francisco. President is talking about maybe breaking up the 9th Circuit. So that system, also you notice that the Constitution doesn't say how many justices will sit on the Supreme Court. In the early days of the nation, the original Supreme Court, I believe, was 7 justices. Eventually, I'm not sure when, that was expanded to 9. Has never been more than 9. Although there's a really interesting piece of history back in the 1930s when President Roosevelt tried to do what was called a court packing scheme. He wanted the Congress to say that any time a Supreme Court justice reached the age of 70, they could stay on the court, but a new younger justice could be appointed in addition, up to, I think, a total of 15. It was laughed out of Congress. Didn't get very far. What is not in Article 3 that sets up the judicial power of the federal government is what we've been talking about, the authority of the courts to say what the Constitution means. It's not in the Constitution. But very early on, in 1803, Chief Justice John Marshall, another fascinating personality in the early days of the Republic, wrote an opinion in a case called Marbury versus Madison. The details of the case don't interest us right now. It's kind of arcane for lawyers to study. But essentially what Marshall said, the key language, a law repugnant to the Constitution is void. It's a power that the Supreme Court, in effect, took on itself. Although I think it makes sense, and maybe that's just my law school training, but the courts are called on to enforce the laws, and if a case is brought to them under a law that the justices of the Supreme Court think is repugnant to the Constitution, they can't, in all honesty, enforce that law. So to me, it makes sense. But that has been the policy of the courts and of the functioning of the government. The other branch, and it does act as a check and balance on the other branches, very much so, although the other branches have not always completely respected that. President Andrew Jackson, who had a personal feud with John Marshall for decades. They didn't like each other. Marshall came down with a ruling on a particular thing that Jackson wanted to do as president, and Jackson said, fine, let Marshall enforce his own opinion. And of course, the Supreme Court has no way of enforcing it. It depends on the executive branch and the legislative branch to follow its rulings. I think what Jackson wanted to do was send a military expedition against the Seminoles in Florida. And I think Marshall said, in the particular way Jackson wanted to do it, you can't do it. And he wasn't impressed. So we have the first three articles, legislative, executive, judicial, gives us the skeleton, the framework, the outline of how our government is supposed to operate on a very basic level. But as we're seeing, there's a lot of blanks to be filled in. And that's part of what's been going on, part of what we as a people, we as a nation have been doing for the last 240 years. And I've often felt, as long as we're still talking about it, as long as even we have differences of opinion on it, that may be a healthy thing. If we ever reach a point where most of us agree and we shout down the few who don't agree, then we're in trouble. That's an opinion. The next few articles are, in a sense, procedural. Article 4, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. It's a little bit technical. New states may be admitted by the Congress into this union, but you can't split up a state and have it come back in as 2 states unless the legislature of that state agrees. So that's some protection. Mode of amendment, this is important. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments. So, member of Congress can introduce a proposed constitutional amendment, has to be passed by 2/3 of each house, and then it has to be affirmed, ratified by the legislatures of 3/4 of the states. Now, there is a provision in there that the Congress can say that not the legislatures, but each state will call a special convention to determine whether it will ratify. That has yet to happen. It's always been Congress passes by 2/3, 3/4 of the states ratify. 2/3 of the state legislatures can call for a new constitutional convention. It's never happened yet. Last I checked, 29 states have voted to call for a new constitutional convention. 5 more are needed. Yeah, and just as the original Constitutional Convention of 1787 way exceeded its mandate, if enough states call for a constitutional convention, there's really no limit on what that convention can consider. I'm not sure, I don't think that Colorado has been one of the states to call for that. I don't think there's any statute of limitations on it. But again, it's unknown territory. It hasn't happened before. So stay tuned. But the amendments proposed by the convention would still have to be ratified by 3/4 of the states. Correct. So there is that protection still. Article 6, paragraph 3 includes this statement: no religious test shall ever be required as a qualification to any office or public trust under the United States. So neither the federal government nor any state can pass a law saying, oh, for example, Catholics can't be elected to office, or Jews can't be elected to office, or Muslims can't be elected to office. Can't stand under that phrase. Now, that's got no control over how people vote. That's simply whether there is a test in law to serve in a public office. And also, most of the Constitution speaks only to the federal government. This kind of language includes the states as well, under the United States. Well, that's the original Constitution in its essence. When the Constitution was sent out to the states for ratification, some people in the ratifying conventions in some of the states said, we don't want to approve this, there's no protection for civil rights. There's no protection for there's no Bill of Rights. And some of the members of the Constitutional Convention, the Federalists, so-called, said, well, there doesn't need to be, because nowhere does it say in this document of delegated powers that the government can take away those rights. And a lot of people said, we don't care, we want it spelled out. And I know for a fact that there were quite a few people in the New York State Convention that refused to ratify unless there was a promise that there would be a Bill of Rights passed as soon as possible once the Constitution went into effect. The people who were pushing the Constitution said, okay, we'll agree to that. It was ratified, and very early on, 1791, 2 years after Congress first convened, the Bill of Rights was ratified. Actually, there were 12 amendments that were included in it. 2 of them at the time did not pass, did not get ratified by enough states. We were left then with what we have come to know as the 10 amendments of the Bill of Rights. These have become so fundamental to how our system functions that we have to be familiar with them. We have to see what's going on with them. Some of them are a little more obscure, some of them are a lot more out there and under discussion. First Amendment has several. The very first thing that's included in this Bill of Rights is freedom of religion. Very first thing. Congress shall make no law respecting an establishment of religion or prohibiting free exercise thereof. Establishment of religion meant that whatever your own religion was, you paid taxes to support the established religion of the state, which in most of the early states was the Anglican Church, the Church of England, later to become the Episcopal Church in America. In New England, it was the Congregational churches. And in fact, gradually, and remember, it says Congress shall make no law. So this didn't originally apply to the states. But very early on, the states started doing away with established churches in the states. And I think the last one to do away with it was Massachusetts in the 1820s, I believe. So 30 years after the founding of the Republic. Free speech, freedom of press, right of people peaceably to assemble and to petition the government for a redress of grievances. These are so basic to what this country is about that we need to know about these. Yes?
Sorry,
The question is that the First Amendment doesn't only apply to citizens, it applies to anybody.
I'm not sure.
Well, the courts have never been in complete agreement with that interpretation. The Supreme Court in the 1940s upheld the holding of citizens and non-citizens of Japanese descent in camps. And they justified it by saying it's a time of war. I have seen arguments today about whether or not, one of the arguments against the president's executive orders having to do with who's going to be allowed in the country, one of the arguments against it was that it seemed to target Muslims, and that this would be a violation of the First Amendment. The current state of the law is that it is being applied, but it hasn't always been the case. And it could go back, it could change.
So it hasn't totally been decided?
Nothing is ever decided in a completely final way. It's been pointed out by constitutional scholars that the Constitution means whatever the current Supreme or the last Supreme Court to decide on an issue says it means, and that has changed. My classic example of how that has happened, 1896, the Supreme Court of the United States ruled that separate but equal accommodation of people of different races is perfectly acceptable under the Constitution. Just under 50 years later, the same institution, obviously different people, in Brown versus Board of Education, ruled separate is inherently unequal. What comes next? Stay tuned. Yes, sir. Not the Constitution. There is a provision in the Constitution that says in time of war, what it says is that the writ of habeas corpus may not be suspended except in time of war. And I think that was the basis for the Supreme Court's ruling on the Japanese internment camps. And it was also President Lincoln during the Civil War suspended the writ of habeas corpus. But that's just the writ of habeas corpus. That is not the whole Constitution. You have to have a lawsuit. The courts, the United States courts are not proactive. In some countries, the courts are proactive. I believe in France and in Spain. The courts are in effect also the prosecutors. Not the case in the United States. The courts here are not proactive, they are passive. Somebody has to bring a suit, a legal action, whether it's criminal or civil, depending on the issue, before the courts will act. And then it has to climb the ladder of the appellate review. And that takes a while. I don't know of any provision by which citizens can remove somebody from office by litigation. The courts don't have the power to remove somebody from federal office. Only Congress does by impeachment. But then the Congress would have to vote, if they're convicted in the court of public opinion, or if they're convicted of a crime. Yes, public opinion would probably force that body to expel that member, which the body can do. But no, the citizens cannot, the courts will not remove somebody from public office, certainly not from elected office. Second Amendment has been from time to time the subject of discussion and litigation. And the argument really is you can divide, it's very short, right? And you can kind of divide it up into two parts, and that's what the discussion has been. Which part of it gets the emphasis? A well-regulated militia being necessary to the security of a free state. Hold that thought. The right of the people to keep and bear arms shall not be infringed. Okay? If the first part wasn't there, the second part would be a lot clearer, right? But with it there, how does that change the meaning of the last part? And that has been the subject of litigation in the courts. At the moment, it's not tremendously clear. The latest ruling has been that people do have the right to have arms, but the argument's going to continue. Amendment 3 is one that there has never been any litigation on. This is something that the British were doing in the colonies during the colonial period. They were quartering soldiers in private homes at the expense of the homeowners and without their agreement, and they wanted to make sure that's not going to happen. As far as I know, the government's never tried to do that. In the South, I think, to some extent, and probably, from my understanding, quite a few times that it was done not right, not legally and not the way it could or should have been done. But that was in a period of war. It's people get carried away. Fourth Amendment. The key phrase here is no warrant can be issued for arrest or for going through your houses and papers and effects without probable cause. Police can't search without a warrant, and they can only get a warrant for probable cause. Yes? Yes, there's currently an issue about the police taking money or private property that they think has been used in the furtherance of criminal acts, and even after perhaps the charges have been dismissed or the person has been acquitted, they don't get their money or their property back. That is the subject of current litigation. And I think we just have to stay tuned and see what the courts are going to do with it. At the moment, it appears that the law permits that. But whether the Constitution permits that, the courts are going to have to decide. Asking for passwords on phones and computers at airports and such. Again, this is new territory. When the Fourth Amendment was written, they didn't have cell phones and computers. They probably couldn't even imagine something like that. They're thinking about the police knocking on your door at midnight and barging in and going through everything, right? Which the British authorities did during the colonial period. As technology has advanced and changed, it's all had to be litigated. That one too is going to have to be litigated. The famous Fifth Amendment. No person, nor shall any person be subject, first of all, subject for the same offense to be twice put in jeopardy of life or limb. This is called double jeopardy. If you're acquitted of a crime, you can't be tried for the same crime again, even if new evidence comes up. The state has one shot at you, and that's all they get. Nor shall be compelled in any criminal case to be a witness against himself. This is the famous taking the fifth, which, if you've been reading the news, General Flynn is claiming Fifth Amendment to prevent him, to keep him from testifying before congressional committees. It's designed so that nobody is forced to incriminate themselves. In so many non-democratic countries throughout history and still currently in many places in the world, we've seen coerced confessions. And that's the kind of thing that I think the founders were trying to prevent, trying to avoid. And if you've watched Law and Order, you know it's entirely up to a criminal defendant whether he or she testifies in his or her own defense. But once they do, they're subject to cross-examination. So it's always an important strategic decision on the part of the defendant and that defendant's lawyers. Nor shall anyone be deprived of life, liberty, or property without due process of law. And this goes to the question of a moment ago about the police confiscating money and property and then not returning it if the person is acquitted. There's been no due process of law to deprive that person of those things. For whatever it's worth, my opinion is that's unconstitutional based on this. We'll see what the courts say. There are always other arguments. And nor shall private property be taken for public use without just compensation. Eminent domain, exactly. A public agency has the authority to take private property for a legitimate public use, but the owner must be compensated fairly. And where there's litigation, it's never about whether or not the government agency has the power to take the property. They do. The question is always compensation. What's a fair compensation? Sixth Amendment. In criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. No star chambers, no dragging it out by the government. And this is why, for everybody's benefit, we got to make sure the system works right. You know, lawyers who make their living defending criminal defendants, you know, often face criticism. How can you defend people like that? And the answer is they're not defending the individual, they're defending the system. Because I got to tell you, if I'm ever wrongfully accused of something, I want the system working real good. Real good. 7 has to do with civil suits, really doesn't have much effect anymore. 8, no excessive bail or excessive fines, or, and the part that's usually argued about, cruel and unusual punishment. And it's a very subjective phrase. I will give you that. It is very subjective. It isn't a very satisfactory answer that I'm going to give you. And the question had to do with the interest of the victim isn't really taken into account in whether or not a punishment is cruel and unusual. It isn't a very satisfactory answer, but the basic answer is that the victim is not actually a party to the litigation. There are laws that have given the victim a voice in the litigation, but the actual parties to the litigation are the state and the defendant. Article 10, and 9 again is kind of technical. 10, powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. This has been cited many times in litigation that argues between, and this is an argument that's been going on since the founding of the Republic and will no doubt continue forever, the argument about a strong federal government versus the rights of states. In a technical sense, that's what the Civil War was fought about, but on into modern times, the argument continues. The question has to do with whether the Ninth Amendment has ever been used in litigation to, say, argue against a current issue before the courts, where some people are claiming that religious freedom gives them the right to discriminate against other people. I will be very honest with you, I am not up on all the details of that ongoing litigation. That's how I would read it, but again, it doesn't matter what I think or what you think, it matters what the court thinks in the end. Okay, that's the Bill of Rights. Think about how often those things listed in the Bill of Rights are invoked, that come up and are living in this country and living in the system that we do. Now we're getting into additional amendments, and you know, frankly, there have been 27 amendments in 240 years. If you take out the 10 for the Bill of Rights, there've only been 17. In 240 years. That's pretty amazing. So very quickly we're going to run through these, and keep in mind what I said early on. One of the things that's going to be happening here is the expansion of the vote to more and more members of society. 11 is a kind of a technical thing having to do with jurisdiction of which court over what. 12th Amendment actually kind of redid, in some ways, the way the Electoral College worked, and the ultimate result of it was before the 12th Amendment, which was 1804, I think? Yeah, 1804. People ran for president, and whoever got the most votes was president, and whoever got the second highest votes was vice president. They didn't run on tickets like we're used to now. And they very quickly saw that wasn't working because you had people of different parties. The founders had hoped there wouldn't be parties. Sorry, didn't work. So that was the main effect of the 12th Amendment. 13th Amendment, following the Civil War, 1865, abolishes slavery, both federal government and state governments. 15th Amendment, also in the wake of the Civil War, 1868, this is where the rule comes where anybody born in the United States is a citizen, or if they're naturalized under law, and no state. Remember, Bill of Rights applied to the federal government. Now, a lot of them are being applied to the states by amendments. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. Due process and equal protection have been the basis of huge numbers of cases in the Supreme Court, in the federal courts, since this passed in 1868. This is very, very central to a lot of what goes on now. 15th Amendment extends the right to vote to anyone who may have been a slave before the Civil War. And it will not be denied on the basis of race, color, or previous condition of servitude. There's the slavery. At this point, we're still assuming it's men. Stay tuned. 1913, 16th Amendment permitted the federal government to impose an income tax. There were many people who felt that that was not constitutional before that amendment. They passed an amendment, by golly. 17th Amendment is what changed the election of senators to direct election by the voters. 18th Amendment was prohibition. That was such a big success that a few years later they passed another amendment withdrawing that amendment. That's the only time that's ever happened, that one amendment was passed to do away with another one. 19th Amendment, vote gets expanded to women. Now before this, the states could give voting rights in state elections to women, and some did. But in 1920, it became the basis in all federal elections. And I'm kind of amused by the language, how language changes on account of sex. Today we probably say gender. 20th Amendment changed when a new president was inaugurated. It had been March. This puts it back to January. Faster communication, faster travel. It didn't need to be such a long period of time. 21st, repealed the 18th, prohibition. 22nd, term limitations for the president, passed in the wake of Franklin Roosevelt being elected 4 times. 23rd, District of Columbia gets to vote for president, which they had never done before. In fact, there's a provision in the original Constitution that says people living in the seat of government shall not have the right to vote for president. They're still not represented by voting representatives in Congress. They do have non-voting representatives in Congress. During the Civil Rights era, 24th Amendment abolished any poll tax that was being imposed by many of the southern states on people of color. 25th Amendment has been mentioned in the last few months. This makes it clear that the vice president becomes president if the president resigns or dies. That wasn't clear in the original Constitution. When the first death in office happened, William Henry Harrison in 1841, a lot of people figured that his vice president, John Tyler, was only acting president and they'd have to call a new election. Tyler just said, no, I'm president. And that stuck. But this also provides for removal of the president from office if the president is incapacitated, physically or mentally, and the vice president can initiate that with agreement of a majority of the cabinet. I recommend going and reading this. It's a very interesting language, but this could come into play. The cabinet with the vice president can report to the Congress that they believe that the president is incapacitated, which triggers this, but the president can then send a message to Congress saying, no, I'm not, I'm fine. And if the vice president and the cabinet members don't back down, then Congress decides. Woodrow Wilson was incapacitated for the last 1.5 to 2 years of his presidency. He had a stroke. And everybody basically knew that his wife was running the country. But she'd never been elected. So I think that was the impetus, but it didn't happen until the 1960s, 40-some years later. So it took a while. If this is ever, if you watched The West Wing, this provision gets invoked when the president's daughter gets kidnapped by terrorists. If this ever gets invoked in real life, it is tremendously complicated And it's going to be ugly if it ever actually happens. 26th Amendment during the Vietnam era lowered the federal voting age to 18. And the 27th Amendment is amusing. It was passed by the Congress and sent to the states in 1789 as part of the original Bill of Rights. But not enough states ratified it, and it just sat there for a couple of hundred years until back in the 90s, I think it was, some citizen, 1992, there was a citizen who saw it on the books that it had been out there. He said, I think that ought to be passed. And he started writing letters to members of state legislatures that hadn't considered it. And of course, there were a lot more states now than there had been when it was first sent out. So it needed to be ratified by more. But he got enough states to ratify it so that even though it was sent out to the states in 1789, it didn't get ratified till 1992, which shows, there's no statute of limitations. Now, on some amendments, Congress now says this has to happen within 7 years. Has to be ratified by enough states. And that's what happened to the Equal Rights Amendment that was passed by Congress and it said it had to be ratified by enough states within 7 years. Didn't happen, died. We had to rush through the last part. You've been very patient. I thank you for that. There's so much more that could be said. I wanted to show you an annotated Constitution online, congress.gov/constitution-annotated. Just Google annotated Constitution and it'll come up. And it lists all the cases and commentary from constitutional scholars about what each provision means. And they talk about how cases down the years have changed the meaning or added to interpretation of those. Whatever your political opinions, whatever your political viewpoints about what's going on today, there are serious constitutional issues under discussion that may come to the fore and really inform how we as a nation continue. There's a story that on the last day of the Constitutional Convention, as Benjamin Franklin was leaving Independence Hall to walk home, the wife of the mayor of Philadelphia stopped him on the sidewalk and said, "Dr. Franklin, what kind of government have you given us?" And Franklin's answer was, "A republic, madam, if you can keep it." We're still testing that, if we can keep it. Let's all be informed. Let's be active as citizens, whatever our points of view are. Thank you for your kind attention.